I'm fine.
Okay. We'll call the last case then, MULREANY versus Lake Poinsett homeowners.
Your Honor, I'm Jerry Jester. I'm from Merritt Island, Florida. I'm here on behalf of the excuse me, the appellants Terrance P. MULREANY and Peggy MULREANY, his wife. This case is about lien rights of a homeowners association and the homeowners association to authority and power to levy assessments against the homeowner.
If you could speak up just a little bit.
I'll try, Your Honor.
Okay.
My throat's kind of dry right now.
Okay.
What we had here was a declaration of covenants and restrictions for a 6-lot subdivision. The 6 lots are owned by 4 couples. There's a 7th lot that's owned jointly by the couples. There's a 1/4 mile entry road from the county road into the subdivision. And the subdivision lots actually have within them a 66-foot wide ingress-egress utility easement. The assessments that were made by the homeowners association that were questioned by the appellants were maintenance on the 7th lot, graveling the 1/4 mile entry road from the county road into the subdivision, repair of a septic system outside of the utility easement, and payment of attorney's fees for individual members of the homeowners association for repairing the septic system.
Is there any dispute that your clients were responsible for sharing in the cost of maintaining the entry road?
No, sir.
What's the evidence that the work that was done on the entry road wouldn't qualify as maintenance of that road?
As maintenance?
Yes.
Well, because
I understood your argument to be, yes, they have to share in the maintenance, they don't have to share in the expensive improvements. Is that a fair?
Well, that would be an argument, yes, because the road originally was dirt, and they improved it by making it gravel.
Why is that not potentially simply maintenance of the road rather than improvement?
Because it's an improvement to the road, I think.
Do we have any evidence that it's cheaper to maintain a dirt road than it would have to put gravel on it because it's then less maintenance over time or anything like that?
Well, obviously you don't have to put gravel on a dirt road. All you'd have to do is straighten it out a little bit.
Well, you'd have to grade it every so often. Maybe there's less work once you put a layer of gravel down, for all we know, right?
Well, the association has the right to make assessments for costs to maintain rights-of-way and easements.
Excuse me?
I said, are we referring to the language that says that the association has the right to make an assessment for costs to maintain rights-of-way and easements? Is that the language that the right to assess arises out of, and the word maintenance, where the word maintenance comes from?
Here's the problem. The covenants and restrictions state explicitly that they encumber the 6 meets and bounds lots in the subdivision. It does not state that it encumbers the 7th lot. It does not state that it encumbers the entry road. They're not described in the covenants and restrictions. There is a right-of-way within the lots called Angler Drive. It does say that they can maintain utilities. It does say they can maintain the right-of-way, but there is a right-of-way that is encumbered by the covenants and restrictions. The entry road is not.
I see.
The entry road...
But do you agree that they have to share in the cost of maintaining the entry road?
What I don't agree is that the homeowners association has any authority to go maintain that road, number one. And number two, they have no right to lien for maintaining that road. That entry road consists of one half of it as an easement and one half of it as a lease. And that easement and that lease runs to the individual owners of the lots, not to the homeowners association. It says that the individual owners of the lots have a right or have a duty to maintain that entry road. It doesn't say the homeowners association does.
What is it?
Excuse me?
What is it? You said it says, what is it?
The lease and the easement both are almost identical. They both say the individuals have a duty to maintain the road, both roads, the lease and the easement. It doesn't say anything about a homeowners association.
Who are the parties to the lease agreement? Who are the parties to the lease agreement? Is it the individual lot owners or is it the homeowners association?
Individual lot owners.
Same for the easement?
Yes, sir.
All right.
And
The homeowners association is not referenced in either the lease or the easement?
no, sir.
All right.
And that's our theory, or our argument, is that the entry road is not encumbered, specifically states that it's not encumbered, by the covenants and restrictions. It says these covenants and restrictions restrict the 6 meets and bounds residential lots. That's all it says. It does say in there, as Judge Griffin said, that the homeowner association has a right to maintain the rights of way and easements, but there are rights of ways and easements within the 6 lots,
Well, who's supposed to maintain this road then?
the 6 individuals.
I'm talking about the other part of the roadway that you say is not encumbered by
Right.
their lease.
Yes, sir, the 6 individuals.
6 individuals are supposed to do that?
Yes, sir. And that's fine, but that doesn't give the homeowners association a right to put a lien on my client's homestead and foreclose it for not paying part of that assessment. That was made by the homeowners association, not the other.
You're saying the assessment was for putting the gravel on the
Yes.
road?
Well, that was one part of it. The other part of it was they went clear out to the county road and they repaired the culvert and they repaired the concrete.
You're saying that the gravel is an improvement, not a maintenance of the roadway?
Well, I think it is an improvement of the road and not maintenance, but either way, I don't think the homeowners association has a right to lien for either one.
Is it your position they didn't have standing to?
Excuse me?
Is it your position that the homeowners association didn't have the right to sue for either the money or for a lien right?
Yes, sir, because it's not within the authority of their covenants and restrictions. The same is true with Lot 7. I mean, the covenants and restrictions say that they encumber 6 lots, not 7. And the homeowners association decided to landscape or clean up or whatever you want to call it, cut weeds, take out trees and things on Lot 7 and assessed for that as well.
Lot 7 was owned by the 6
individuals.
lot owners' undivided interest.
Yes, common tenancy.
Right, and there is no homeowners, or there are no covenants or restrictions that refer to that 7th lot?
I would say that would be the appellate's position. The covenants and restrictions do refer to a common area, but it doesn't say what that common area would be. And it also says specifically, in the first paragraph, these covenants and restrictions hereby restrict the 6 meets and bounds lots.
Is there anything in the record that would indicate that the homeowners association had repaired or maintained the road before and that the assessments were paid? Is there anything in the record that would indicate that may have happened in the past, that would lend some sort of practice in the past that may have caused them to make the improvement and then make the assessment?
No, sir. What happened was...
Nothing in the... Go ahead.
What happened was that the appellants were the first people who bought a house in this subdivision. When they bought their house, there was only one house in the subdivision, just their house. Everything else was just a field. The entryway was a dirt road from the county road into their house. The appellants actually performed the maintenance on the road until such time as the homeowners association got established again afterwards.
And then after the homeowners association was established, you're saying that the road was maintained by the lot owners?
Well, the first thing that happened was that the homeowners association decided to go perform maintenance on the road.
Okay, I see.
They gravelled it, they repaired the entryway off of the county road by replacing the culvert and the apron over the culvert off of the county road. And I think they repaired another culvert, and they assessed for all of that. And put a lien, I might add, on the appellant's lot for not paying it. The appellees would say that the homeowners association has, according to the covenants restrictions, the power to assess for any purpose on any property that they want to. And I would suggest that that finding of fact in the final judgment is not quite accurate, because what it actually says in the covenants restrictions is the association shall make an annual assessment for each lot in the project by action of its board of directors for any purposes approved by the committee, including but not limited to maintenance and certain other things. It doesn't say they have the power to assess for any purpose. It says they shall assess for any purposes approved by the committee. They're talking about assessments, and I think what they're saying is the committee is limited to doing what is authorized in the covenants and restrictions, which was to maintain the lots.
Well, where does it say to maintain the lots?
There's an entire paragraph 19, which sets forth 3 or 4 things that the homeowners association can do. It can maintain the lot if the homeowner doesn't. It can maintain the homeowner's house if he doesn't. It can maintain his shrubs, his grass, and so forth if he doesn't. And it can maintain his utility connections if he doesn't. Then it goes on to say that they will make assessments for any items approved by the committee. It's very poorly drawn covenants restrictions. The committee is set forth therein, but doesn't seem to have any functions that I can see in here other than approving architectural plans and things. But that's what it says. I don't think it actually says that the homeowners association has all the power at once. Otherwise, this would have been a pretty simple document. You'd just say, these are covenants restrictions, the homeowners association can do anything it wants. Why would you bother trying to set forth what things they could do?
Were there rights of way and easements within the property that's described in the covenants and restrictions?
They're not described in the covenants. Nothing is described in the covenant.
No, I said within the property that was described, in the legal description of the property covered by the covenants and restrictions.
Yes, sir.
Did that piece of property have easements and rights of way on it?
Yes, sir.
Okay.
Did it have common areas?
If the easements and rights of way are common areas, then I would say yes. But
there aren't common areas, as might be typical with the homeowner association, where there's an entrance, for example, with a wall on it that's owned by the association.
No, there's a 7th lot, which consists of a pond and a vacant piece of property, which is, I said before, jointly owned by the individual owners.
But the association doesn't hold title to any real property, is that correct?
The association has no property that I know of. The other problem is the septic system.
Let me talk to you, let me skip, because I want to ask you some questions about the attorney's fees piece of the assessment.
Okay.
Talk to me about the nature of the lawsuit that was brought, who were the parties to it, and what was the homeowners association involvement, or if any, in the lawsuit.
Okay, to do that, I have to talk about the septic system,
Okay.
which is just where I was starting to go. When Mr. Mulreany bought his house, as I said before, it was just the house and a vacant field of weeds. There was no roads or anything else in there. He was told by the realtor and the seller that he was on a septic tank. The house had been vandalized. They flushed the toilets, they worked fine. Okay, they had a certificate of occupancy. They liked the looks of the property, they bought the property, they moved in. Sometime after they moved in, they were told by the other owners, several of the other owners, that, oh, by the way, Mr. Mulreany, we're going to pump our septic to your lot and put it through your drain field. And he said, why are you going to do that? There's no easement for you to use my septic. I have a survey, I have a title policy, and I have an easement. Nothing here except my septic. They ignored that advice. This is before they started building. They ignored that advice, they started building, they built their houses. At that particular point, when they first started building, Mr. Mulreany, Mr. and Mrs. Mulreany filed a lawsuit against them, asking for an injunction, asking for...
Against them being the homeowners association or the individuals?
Two individual homeowners, Mr. Thrift and Mr. and
But
Mrs.
not the homeowners association?
Not the homeowners association. And what the purpose of that lawsuit was to stop them from pumping their septic to Mr. Mulreany's septic tank, number one. Number two, to make them get their own drain field and not use his. Now, during the course of that lawsuit, which is still pending, I might add, during the course of that lawsuit, Mr. Thrift filed a motion to dismiss for failure to join an indispensable party, namely the homeowners association, and that motion was denied. Now, regardless of that fact, the homeowners association paid for both Mr. and Mrs. Hoffman's and Mr. and Mrs. Thrift's attorney's fees in that lawsuit, and assessed my client for part of them, but not all of them. The trial court found...
How many members are there of the homeowners association?
There would be 6. 4 couples. The 4 couples own 6 lots. 2 of the couples own 2 lots each. The trial court found that there was constructive notice on the part of Mulreany's of the drain field being in his lot. And there's several, I think, erroneous findings of fact. Mr. Mulreany testified...
You're down to about 2 minutes, by the way, in case you want to save any time for rebuttal.
Well, I wanted to say these 2 things. That Mr. Mulreany testified that in 2000, when he bought his lot, he didn't see a drain field. If he did, whatever he saw, thought it was his, because he was told he's on a septic tank, and the toilets worked, and he was happy. Okay? The court said that Mr. Thrift looked, that sometime before Mr. Thrift bought his lot, that he looked and saw a huge mound in Mr. Mulreany's lot. If you look at the actual testimony, first of all, Mr. Thrift said that he looked at it in 1998. That would have been either 1.5 to 2.5 years before Mr. Mulreany looked at it. So why that would be, what he saw would be constructive notice to Mr. Mulreany. I think things change in 2 years. And Mr. Mulreany testified that he didn't see anything, which was not controverted. Secondly, he did not say he saw a huge mound. If you looked at testimony, he said he saw a large drain field. He said he had experiences with drain fields, and he knew what a large drain field was. that this property had been commercial at one point, according to Mr. Thrift. Mr. Mulreany did not testify that he had any experience with drain fields. He wouldn't have known a drain field from the toilet. Secondly, it says in the final judgment that Mr. Thrift saw a lift station on all 6 lots. If you look at the actual testimony, Mr. Thrift said he did not see a lift station on Mr. Mulreany's lot. So, there's obviously the pipes that run from the drain field to the other lots are underground. You can't see them. The other thing they said was Mr. Hoffman got a copy of the permit at the health department. It was not recorded in the public records, the official records.
Well, isn't the issue as to the drain, the septic system, whether your client was on constructive notice of the shared septic system agreement?
Yes.
Well, even if he was in constructive notice of the shared septic system agreement, how would that give rise to an entitlement on the part of individual homeowners to recover their attorney's fees from the homeowners association?
I don't think it would in that instance.
I understand that that's your position, but I don't even get what the argument would be.
Well, the other argument is that they came, when the septic system was tried to be used by the other 2 parties, it leaked. And so the homeowners association came up to Mr. Mulreany's lot and dug it up, and replaced all the pipes, and charged my client a 1/6 share for making that replacement, even though there's no easement in his lot for this drain field to begin with. The covenants restrictions say that they can maintain utilities inside the utility easement. This is not inside the utility easement. If he was on constructive notice of it, then he would be aware that then you basically have extended the easement, I guess, from the 66-foot easement to whatever you saw. Thank you.
Thank you.
Good morning. May it please the Court, my name is Van Catterton. I represent the appellee, in this case, Lake Poinsett Homeowners Association, Inc. I'm going to take a different tack. Before I plunge in, I would invite any questions the Court may still have while they're fresh in our minds on the issues Mr. Jester has discussed.
Let's start with Lot 7. What rights, if any, did the Homeowners Association have to do anything with regard to Lot 7, to make any assessments or assert any liens?
We have 2 arguments there, Your Honor. First of all, it's correct that the restrictions themselves do not reference Lot 7, but in the root deeds to each of the individual lot owners, each owner was given a fee simple interest in their particular lot, in the appellant's case, Lot 1, plus a 1/6 interest in Lot 7. Those properties were described on Exhibit A. What the deed said in each of these instances was, and our contention is, first of all, that the deeds themselves imposed the restrictions on Lot 7, and let me tell you why. The deed was a standard deed form, and it said, we hereby convey the property described on Exhibit A, which included both Lot 1 and the 1/6 interest in Lot 7. And then the deed said, subject to restrictions attached hereto and made a part hereof. So we would argue, first of all, that the root deed itself imposed those restrictions, not only on the number.
What were the attached restrictions?
The attached restrictions were the covenants we're discussing here today.
And in the covenants...
The covenants themselves only reference 1 through 6.
Okay.
Yes, that's correct.
So how would a deed which says we give you Lot 1 and a piece of Lot 7 pursuant to the attached restrictions, if the attached restrictions only apply to Lot 1 through 6, how does that create any right vis-a-vis Lot 7?
That's what the appellants are arguing. They're saying, hey, wait a second, the restrictions themselves only reference 1 through 6. We're saying the deed subjected both interests to those restrictions. But let's assume...
I still haven't followed your argument. How does the deed with the attached covenants, which are limited to lots 1 through 6, somehow attach those restrictions to Lot 7, which isn't covered by the covenants?
Because the deed itself conveyed the interest in Lot 7, and the property the 1/6 interest in Lot 7 was described on Exhibit A, which was made subject to the restrictions attached here too. But for the sake of discussion, let's assume that we're just looking at the restrictions themselves. What we start with are two things. Number one, the very broad grant of authority to the Homeowners Association to levy assessments, and number two, the very broad grant of authority and powers that were conferred upon the association. The broadest assessment authority conveyed in these restrictions, and virtually all of them are set forth in paragraph 19, provides, as Mr. Jester said, that the association has the authority to levy assessments for any purpose.
I thought the association could do that based on the purposes approved by the committee.
Correct.
And then, well, what is the committee? What is the committee authorized to do?
Well, that's the second aspect of it.
Right,
the committee should be authorized to approve any purpose which falls within the powers of the corporation. Again, we have a very
So if
broad...
they decided they wanted to improve a lot that was a mile down the road,
No.
could they do that?
No, we would never argue that.
Why not?
Because I think there has to be at least a standard of reasonableness imposed on this, and I think the association's assessments in each and every case meet and satisfy that standard of reasonableness. For example, with the authority that Judge Sawaya just asked about, the declaration gives the association all powers which are granted to any not-for-profit corporation. We look at Chapter 617, we see the real property subsection, which provides in very broad terms, every corporation shall have the right to purchase, lease, acquire, improve, hold, or otherwise deal in real and personal property.
Well, but I thought the point here was that the Homeowners Association had no property rights.
I understand, Your Honor, but the association has the authority to deal in and improve and hold and use any interest in real or personal property wherever situated.
Have all the rights it wants. It just, as a matter of fact, doesn't have any.
I'm sorry?
It just, as a matter of fact, it doesn't have any.
Well, I think if the association has the authority to deal with real property, okay, and if
All right, what if the association decided it would be nice to have a 200-foot landscape buffer around this subdivision?
Sure. Right.
So we're going to go to all the neighbors and we're going to agree, we're going to get an agreement with them, and we're going to landscape all those buffers, and we're going to charge it to all the homeowners.
Right.
Can they do that?
Well, again, no, a lot depends on the facts, but I would still be willing to concede that a standard of reasonableness has to apply here.
Well, but why is it any more reasonable on the neighbor's lot than it is on a lot that the homeowner association has no interest in but happens to be owned jointly by the individual members who happen to be members of the homeowners association?
Well, for the most pressing reason was the fact that this lot was overgrown. It was on the edge of the waters on the nearby the St. Johns River. It was overgrown, and by the admission of the appellants themselves at trial, it was snake infested. It had not been cleared off. The association, and frankly, through the volunteer labor of the members of the association, went in and cleared this lot off and hired someone else to come in and assist in the mowing and the clearing.
Well, and the homeowners who all own a 1/6 interest in that lot may decide that's a great thing to do. The question is that the homeowners, as owners of that lot, doing it, or somehow, why does it become an association duty or responsibility or right that then allows things like liens against these folks' homestead that you wouldn't get if it was just the owners of the lot who chose to go in and clear the lot?
Sure, and exactly. The appellants are in fact arguing for a system where if they're successful in this appeal, we're all going to go back to COCO instead of the 6 lot owners meeting as members of the association to decide on the work and divide up the 1/6 share of the cost. The 6 lot owners are going to meet individually to decide on the work and divvy up the 1/6 share of the cost. Now, I'm not going to impugn any party's right to litigate a principle, but as a practical matter, the only difference here is that if the appellants are successful, they would be able to refuse to pay that 1/6 share with impunity from the lien proceedings, from the lien authority. I think the declaration clearly grants the authority to do so. For example, in a 5th DCA case, Hagan, which is cited in our brief, I think it was a Judge Coward decision. The association was granted the authority to purchase additional amenities, even though there was no express authority to go out and buy amenities. And Judge Coward's reasoning was the fact that the declaration contained a provision almost identical to, if not very similar to, if not identical, to the provision granted in the All Powers Clause of Chapter 617, the right to acquire, lease, improve, hold, or otherwise use real property. Here in the association... I'm sorry, Judge, go ahead.
I didn't mean to cut you off, but in this particular case, was the work done and then the assessment made, and then the assessment wasn't paid, and then the...
It was probably a combination, Judge, based on the different work we're talking about, and I can't represent as to each specific item whether the work was before.
I guess my question is, and I'm reading from the declaration, and it says the association shall make an annual assessment for each lot. in the project by action of its board of directors for any purpose approved by the committee. I'm still not sure exactly what the committee is empowered to do and not to do, but it seems to me that what the association is supposed to do is assess and then do the work and give the whoever may have an objection an opportunity to come in and object to the assessment before the work is actually done. But it doesn't seem like that was done in this case.
Well, that's what it says on its face, but please keep in mind that annual budgets for associations can be amended at any time, too. There's no question in the record that the appellants were provided with adequate notice of every single meeting of the association.
What does it says shall make an annual assessment. It says they assess. It doesn't say that they do the work and then assess. It says they assess. Seems to me like what a reasonable interpretation of this would be, you make the assessment, and then once you get the assessment done and you collect the money, then you go do the work.
Well, that's often done, Your Honor, but it's not necessarily the universal rule in community associations. Very often you don't know precisely what the cost is going to be. The board will invite bids, for example, and then try to come up with a good estimate of what it is.
So you're saying that the association has the authority to go ahead and do the work, and then after the work is done, whatever that cost may be, then assess?
I think that's so.
How do the people that are living there have an opportunity to say, well, the assessment's unreasonable, we can maybe get it done somewhere?
Here's why. The notice is given to every single owner at the only entranceway to this subdivision. Association meeting, 7 p.m., Wednesday, May 13th. We're going to discuss the assessment for the lot. Now, Mr. Mulreany, the appellant, admitted on the stand he had only attended one single meeting of the association, and all the time he'd been there.
But what happens if you said the association is empowered to do the work first and then make the assessment?
Well, and that may or may not have been the case here, Judge, but I think, and we're talking in general terms, because I think very often you're going to see a variety of cases where the assessment is levied in an estimated amount first, then the work is done later, and then if there's any shortfall, the budget can be amended. But certainly every owner is given the opportunity.
What happened in this case? Was the work done first and then?
I think there was a variety of instances between the septic repairs, the maintenance of the entranceway, and the maintenance of Lot 7. But in each and every case of the work that was done, the association did nothing more or less than what the owners were empowered to do in the first place. They did nothing more than what was called for by the lease, than by the easement. They did nothing more or less than what would have been reasonable for any association to do. They didn't go out and sell off any common areas. They didn't go out and buy any common areas. They didn't prejudice anybody's right to use those areas. They simply maintained those areas and did repairs in two instances at the behest and the requirement of the county that required the work to be done. So I don't think there's any question about the reasonableness. And I think perhaps the timing is not as prejudicial as we can sit here and hypothetically make it out to be, and I think that may be a distinction without a difference in this case. So
let's talk about the entry road issue.
Okay.
First off, where the covenants and restrictions indicate that the association can make assessments for the cost to maintain rights of way and easements, were there rights of ways and easements within the property described within the covenant?
There certainly are. There certainly are.
Okay. Is there any indication anywhere whether these rights of ways and easements apply to any property outside of the legal description covered by the covenants and restrictions?
Well, let me note first of all that the restrictions, and we're not here to nominate this declaration for a Pulitzer Prize by any stretch. As Mr. Jester says, the rights of way and easements are not defined. The rights of way and easements are not expressly limited to the roadway within the subdivision and the utility easement that runs around each lot. Okay. By the way, there's also another easement running around the lots that extends on Lot 7, which is a 66-foot utility ingress-egress easement that is a mere continuation of the easement that the association is otherwise responsible to maintain. But let me back up a little bit, Your Honor, on the lease and the easement. What happened here was when these three individual developers, Mr. Theriak, Mr. Blue, and Mr. Ellis, were developing this, it was a landlocked piece of property, the Lake Poinsett subdivision. So they had to go up to two property owners who owned each half of the entranceway. They got an easement from one. They got a lease from the other. Let me point out two things that were contained in each of those two documents. Number one, the lessee and the donee, the grantee of the easement, were responsible for maintaining that property and their successors and assigns. Also, each document acknowledged the fact that the lessee and the grantee of the easement were going to establish deed restrictions for 6 residential units in the subdivision that was going to have access through these entranceways. Now, again, you know, when I say we're not here to nominate the developer for a Nobel Peace Prize, the easement was not assigned to the association, as should have been done. The lease was not assigned to the association, as should have been done. The common areas were not defined in the declaration, as should have been done, nor were the easements, nor were the rights-of-way. Lot 7 was left hanging out there as an odds and end at the very end of the subdivision on the other side of the lake, owned as tenants in common by all 6 units. There's a great deal of other things the developer could have done here, which would have eliminated many of the problems we're discussing today. But the fact remains, and I don't want to state this as some absolute authority that the association can do anything, but I think we have to give the language in the declaration its plain meaning, as the 5th District Court did in the Hagen case. When a declaration provides that an association can levy assessments for any purpose approved by the committee, and the purposes approved by the committee are well within the scope of the authority granted to the association in the very same declaration, I think that's a reasonable and supportable assessment. Now, certainly this did not come as a surprise to the appellants. The appellants may have been the first persons out there, and indeed that may have been the source of some of the adversity and hostility between the appellants and the other owners as the appellants suddenly realized, gee, we're not the only people out here in this beautiful stretch of vacant property. People are building homes over there and over there and over there. But the fact of the matter is, the lease was of the public record, the easement was a public record, the restrictions and covenants were a public record. These appellants were on constructive notice of an association with very broad powers, and I don't think they can complain now of some surprise or prejudice of the exercise of an authority that was clearly spelled out in those documents. Now,
Well, let me ask you this. The provision of the covenants and restrictions which says they can make their assessment, including but not limited to assessments for repairs to common areas, cost to maintain rights of way and easements, and taxes and insurance on improvements.
correct?
Would that limit their ability to only deal with common areas, rights of way and easements, and improvements, as opposed to dealing with something like Lot 7, which doesn't fit into any of those categories?
No, sir, absolutely not. If we read that provision, what it says is the association can levy assessments for any purpose approved by the committee, including but not limited to. Mm-hmm. So those are given as examples, and they're the obvious examples. You maintain the common areas, which the developer should have defined, the rights of ways and the easements. But what customarily happens here is the reason a developer grants this authority to the association and not to the individual owners is not only because the work would otherwise be done on a piecemeal basis according to 13 or 130 or 6 different opinions, but because the work has to be done in a consistent and coherent manner. And the only way for that to happen as a realistic proposition is for a community association to do it. Let me emphasize and point out, too, that each and every one of these assessments were approved by at least a majority of all the other lot owners, if not, in fact, by every single other lot owner out there. Now, we're not dealing with a huge number of people here. We're dealing in some instances with 4 owners who have owned the other 5 lots or whatever the case may be. But if we look at the record, we see that all those other owners agreed that these assessments would be levied.
Well, I'm sorry, go ahead.
What concerns me is that, as you acknowledge, the conveyance to the association should have been done.
Correct.
Ideally. And the appellant says there is legal significance to the fact that what should have been done wasn't done. And essentially what you're contending is that, and he says, and I'm prejudiced by that, because if it had been done, then there would have been an association with lien rights against me.
Right.
And if it weren't done, then they don't have these lien rights against me. And what you're suggesting is that we should just treat as done that which wisely should have been done.
No, ma'am. No, Your Honor. That's not what I'm suggesting at all. An appellant's primary argument here on the entranceway and on Lot 7, he's framing the issue in terms of the association trying to impose restrictions on property it doesn't own. Lot 7, the entranceway. I don't think anybody's going to argue with the general proposition that, gee, shouldn't an association own property before it seeks to impose restrictions on it? That's not what we're arguing. What we are arguing today is that the restrictions which are admitted and conceded did impose restrictions on the 6 lots in the subdivision, and that the owners of those 6 lots were bound by those restrictions, which contained the authority we're discussing earlier. So we're not saying these restrictions were imposed on the entranceway. We would argue that the root deed imposed the restrictions or subjected to Lot 7 of those restrictions, but the fact of the matter is each and every one of these 6 lot owners took title subject to restrictions which authorized these assessments, and Judge Moxley so found. Now, if I can elaborate a little bit in the few minutes I have left on the septic line repair and amplify a bit on what transpired in the background of the septic permit, what happened was this. The original 3 developers, and by the way, let me go back a moment. The same 3 individuals who signed the lease and the easement up front are the same 3 individuals who prepared the Declaration of Covenants and Restrictions. Let me mention as a point of interest that paragraph 19 also provides that the actions and agreements undertaken by the initial board of directors, which included those same 3 individuals, are going to be binding on the association subsequently thereafter. But going to the septic system permit, what happened was this. The original developers signed an agreement to have a shared septic system where everybody would hook up to the same drain field. They didn't record it. I mean, again, the developer has created a lot of problems for us today. But subsequent to that, in 1990 and 1991, the association applied for and obtained a shared septic system permit. That was granted by Brevard County, not to the individual owners, but to Lake Poinsett Homeowners Association, Inc. That document was contained in the health department of the records of Brevard County. Now, what happened in 2004, a leak developed that I believe the appellants complained about. County came out, looked at it, and saw effluent rising from the ground, and said, we got to fix this. And the association took it upon itself to fix it because the permit was issued in the association's name. Now, the leak, the exact location of the leak could not be identified, so what happened was neither the county nor the plumbing contractor could locate that, so the entire septic line up onto the appellant's lot had to be replaced. Now, this exceeded and went a little bit beyond, perhaps 20 yards, whatever the case may be, beyond the 66-foot easement that the association, on the face of the document, would have been entitled to go on. But if you look at the other aspect of the declaration in paragraph 19, there is another clause that goes beyond the 5-foot easement and the 66-foot easement. And what that says is every owner has an obligation to maintain the connection lines for sewage and septic service, and if they don't do so, the association has the right to go on and do it and lien and collect it by means of lien enforcement procedures. So I would argue that constructive notice of the septic permit was not necessarily required, but even if it is, there was certainly ample physical evidence in the subdivision, as Judge Mosley found. Now, we introduced testimony from another owner who had gone out to the subdivision prior to the MULREANY's purchasing. He saw lift stations on each lot. He saw a huge drain field on the MULREANY's lot. Now, Mr. MULREANY testified to the contrary. He didn't see anything. He didn't notice any lift stations or whatever.
Let me ask you about the lawsuit before we're out of time.
Right?
Apparently, the court determined the homeowner association was not an indispensable party to that lawsuit, correct?
Correct.
They were never made a party to the lawsuit. The party to the lawsuit were individual lot owners who
That's correct.
happened to control a majority of the homeowners association.
That's correct.
Right?
Yes, sir.
Tell me the nature of the lawsuit and why the homeowner association had either a right or an obligation to pay the attorney's fees and to assess it back against the
Sure. The essence of that lawsuit was the defense of the association's septic system permit. This was substantiated by testimony in that original trial by the director of the Brevard County Health Department. We introduced transcripts, or portions of that transcripts, of his testimony. What he was asked was this, very briefly. Question, if the special master were to rule today and say cut the pipe, disconnect Mr. Thrift, disconnect Mr. Hoffman, what would be the impact of that? Answer, well, it would be an instant sanitary nuisance and it would have to file against each of the homeowners. And this is the important line. Also, it would null and void this permit, so even Mr. MULREANY's structure would be in jeopardy. So there's no question that the defense of the lawsuit was, in essence, a defense of the association's septic permit. Now, what the statutes provide on indemnification is that a corporation can indemnify directors, officers, or agents when they're acting in good faith, when they're acting in the best interest of the corporation. Here, I think it's indisputable that a defense of an association's septic system is in the best interest of the corporation. And we'd argue that provided all the legal support necessary for the reimbursement of those fees.
All right.
Did I understand the lawsuit was still pending?
It is, Your Honor. It kind of hung dormant for about a year. Some discovery was filed near the end of the year. But what happened essentially as far as the substance goes is the MULREANY's request for a preliminary injunction was denied. Okay. That was the last formal action. I was not involved in the litigation, but I think that's the last formal action. Their request to get a preliminary injunction to prevent the other owners from hooking up was denied. And we would argue that the indemnification statute goes a bit further than what I've described already. The indemnification statute says that where the director, officer, or agent is successful in defending against the suit, the association has an obligation to indemnify that individual. Now, there's an argument here these folks were sued in their individual capacity. If I can take 10 more seconds to answer. There's an argument here that these folks were sued in their individual capacity, but there's no question that once this suit was commenced, they were defending the validity of that septic system permit.
Well,
There's
but
no
if,
question thereafter.
if Mr. Mulreany succeeds in his lawsuit, they don't have any rights under a septic system permit, do they? I mean, they should lose their septic system permit, shouldn't they?
I'm sorry, I'm not.
If Mr. Mulreany wins that lawsuit, then shouldn't they lose their septic system
think one's
permit?
inherent in the other.
They've got nothing.
I think one's inherent in the other. That's exactly right. In order for let me phrase it a different way. In order for Mr. Mulreany to succeed, he will have to invalidate that permit that the county has granted.
I guess
I
the
don't get
logical
that.
follow-up question to that becomes whether that they've got a right to assess those attorney's fees over against him, or even assume those until such time as that lawsuit's resolved.
I would argue they do under the indemnification statute, so long as the purpose is one in the best interest of the corporation, and so long as the specific purpose is the defense of that.
So under your theory, even if he ultimately wins the lawsuit, you still get to assess the
No, then it
attorney's
would
fees
become
against
discretionary.
him?
No, then it drops up from the level of mandatory indemnification to within the discretion of the board of directors of the
Well, so
corporation.
wouldn't that mean that at least at this point, any assessment that has been made for attorney's fees or any lien that has been imposed because of an attorney's fees is premature?
Not necessarily, Your Honor. Not given the fact that the preliminary injunction was denied. I don't believe so.
Well, what happens if he ultimately wins the lawsuit?
Well,
You've
that's gonna
already
be a
assessed the
that's gonna be a
attorney's
damages
fees,
claim
you've
against-
already attached the lien, you arguably could already foreclose upon the lien.
Well, in this case, the judgment was paid off, so the foreclosure sale was avoided. But you know, if we carry these things to their ultimate end, we can come up with a number of situations that don't make sense from a rational and reasonable perspective. But under the circumstances, I think what was done was in fact reasonable.
Thank you, counsel.
Thank you, Your Honor.